Good morning, everyone, and thank you very much for joining us at our bi-monthly property webinar, the first of 2021. For those that don't know me, my name is Emily Wood, and I head up the real estate disputes team here at DMH Stallard. For each event, each seminar and webinar that we do, we aim to cover 3 or 4 topics or legal updates in the real estate world, and to offer some of our insights and experience on these kind of issues. Well, there was an awful lot to choose for this webinar, so we'll aim to whistle through some reflections of what we've seen in the last year, and then some topics for the year ahead. If you have any questions or comments, then please use the Q&A function on your screens, and we'd love to hear from you, and we'll answer as many of those at the end as possible. If you have any technical issues or you just need to pass a comment to our team, then please use the chat function also on your screens. So in terms of contents for today, first of all, we have Chloe, who's going to give us a planning update on the changes in use classes and changes in permitted development rights. We then have Jonathan, who's going to give a commercial property update covering rent suspension clauses, a recent case on statutory declarations, and a future consultation on MEES. Next up is Cheraine, who's going to give an update on property and insolvency. And then myself, I'm going to talk about business rates, looking both backwards and forwards to the future. And then finally, Lawrence is going to give us a quick whistle-stop tour on repossessing both commercial and residential property for arrears. We aim to wrap up within the hour. There's quite a lot to cover, so let's see how we go. So Chloe, over to you.
Thank you, Emily. Morning all, and thank you for joining us. I'm Chloe Karamian, a partner in the planning team here at DMH Stallard, and I'm going to give you a brief planning update. So there's so much to talk about in the planning world, so much has changed, but we've only got 10 minutes. So I'm just going to discuss quickly the changes to the use classes order and the increase in permitted development rights that happened last year. And I'm going to be looking ahead to this year and seeing what can we expect. Firstly, taking the use classes order changes. This is important because a change of use within the same use class does not require planning permission typically. This can only be controlled or restricted through a planning condition or a Section 106 agreement. Now, the Use Classes Order 1987 was amended last summer by a set of regulations, which had the effect of essentially revoking almost entirely classes A, B, and D, and introducing 2 new use classes, classes E and F. Now, it's important to remember that not all of the uses which form part of the revoked use classes have been included in the newly introduced use classes, and I'll explain a little bit more about that later. Looking firstly at new class E, this is the new commercial, business and service use class. It's extremely wide-ranging. It includes, but is not limited to, retail, sale of food and drink for consumption mostly on the premises, financial services, professional services, indoor sport and fitness, provision of medical or health services, and a host of other uses, including creche and nursery, and uses which can be carried out in a residential area without detrimentally impacting the amenity. So, as I've said, this is an extremely wide use class. It's wider than any of the previous use classes that we saw. It's important and interesting to note because obviously the ability to change use within this use class can result in quite a significant change of use. It'll be of interest to both landlords and tenants. Landlords, when negotiating leases, would no doubt want to consider whether to be quite specific about the permitted user within the lease, rather than granting quite a wide Class E use, whereas a tenant may be more inclined to have a wider use class stated so that they can take advantage of the ability to change use within the use class. It will also be of interest to any applicants for planning permission of any of the Class E uses. They may want to be applied for a wide Class E use rather than a specified use. And we may be seeing more and more planning conditions or Section 106 agreements restricting the use of a property solely to that use and not allowing a wider Class E change of use in the future. And a practical point on this Class E is that the fact that the use classes order legislation which came in last summer to change the use classes is subject to legal challenge. There has been a legal challenge which was dismissed by the High Court last year. Permission to appeal has been sought from the Court of Appeal, but that's still subject to the Court of Appeal's review. So although this is good law at the moment, it does leave a little bit of a question mark as to whether or not permission to appeal will be granted. So we're finding that a lot of practitioners are using reference to the old use classes in their lease as they were last summer. Okay, looking now at the new Class F, this is the local community and learning use class. It's split into two, Class F1, learning and non-residential institutions, and Class F2, local community. Now I think Class F2 is quite interesting. The local community use class now includes shops mostly selling essential goods where there's no other such facility in the area, halls and meeting places, outdoor sports and recreation, swimming pools and skating rinks. These are all local community uses that we probably are more reliant on now over the last 9 months. And by keeping it within the same use class, the government's making it easier to change use to retain a local community use rather than needing full planning permission to apply for a different type of use altogether. As I mentioned earlier, not all of the uses which formed part of the revoked use classes have been included in the new use classes. So that includes these 3 examples: drinking establishments, hot food takeaways, and cinemas. Uses which do not have a use class are known as sui generis. That's a Latin term meaning unique. They don't fall into any use class, so do not benefit from the ability to change use within the same use class. Hot food takeaways, for example, we can see the government's thinking behind this. Over the last 9 months, we've probably become more increasingly dependent on them, and the government's probably trying to stop so many popping up now without needing full planning permission. So it makes it a little bit harder to change use to a hot food takeaway now. And similarly for drinking establishments and cinemas, obviously they've been closed off and on over the last 9 months. And by removing them from a use class effectively makes it a little bit more difficult to change use away from these use classes. So it may be the government trying to secure these uses for the future when we come over the horizon of COVID-19. Looking now at the increase in permitted development rights. Over the last year, a whole host of new permitted development rights have been introduced by the government. 2 of which are quite interesting because they're kind of COVID specific. The first is a temporary right to allow pubs and restaurants, etc., to operate as hot food takeaways. Obviously, having been closed over lockdowns and various tier systems, not able to allow patrons in, that's the only way they could operate as a takeaway. So the permitted development right allows them to do that without needing planning permission. Another permitted development right was introduced to allow the construction of temporary structures for emergency buildings. So that may include things like the testing centres that popped up. But 2 more wide-ranging permitted development rights have been introduced. The first is an upward extension to certain buildings to allow residential on top. And the second is the complete demolition of vacant detached commercial or industrial buildings and their rebuild for residential. These are significant permitted development rights. Normally, full planning applications would need to be provided for full details and all of the planning matters and merits considered. But now, through the introduction of the permitted development rights, effectively the principles established. But in these kinds of applications, a light touch application is needed to the local authority. That's known as a prior approval. And the local authority can take into account only certain matters set out within the permitted development right. So, for example, in respect of the demolition and rebuild for residential, the local authority can take into account matters such as appearance and impact on amenity in the area. So whilst the local authority has got some say on the planning matters related to these permitted development rights, they're not as wide-ranging as they would have been previously. So taking into account the new permitted development rights and the change in the use classes order, it's been quite a significant deregulation in the planning world. More can be done without needing full planning permission. And the purpose of that from the government is to try to get unused properties regenerated and also to allow businesses to diversify. Looking ahead to this year, what can we expect to see? Well, I think we can certainly expect to see more permitted development rights. A consultation closes today, seeking the views on a proposed change of use from Class E to residential. As I mentioned, Class E is a very wide-ranging use class, so that could include anything retail and the like to change to use to residential. At the moment, the proposals are not specific as to where this permitted development right would apply. So it could apply both in a town centre, a high street, and in out-of-town centre retail parks, for example. So that's quite significant, and we'll expect to see something coming forward with that this year. Last year, the government issued a white paper proposing a complete reform of the planning system. Proposals included zoning, replacement of the existing developer contributions system with one national levy, and changes to the way that housing need is calculated. I think we can expect to see more on the outcome of the white paper this year. And potentially, could we see more COVID-19 support as the pandemic continues? The government had extended the life of expiring planning permissions. So those which were to expire between March and December last year were automatically extended to the 1st of May this year, some of which did need an environmental approval to be sought from the local authority. But this is quite an easy win for the government, a simple way to extend planning permissions, keep planning permissions alive, and hopefully keep building going. Although it's not been extended so far, I wonder if there will be a need or a demand for this to be extended in the future. And that's all from me. So if you have any questions at all on planning, please feel free to put them in the Q&A box. I'll now hand over to Jonathan for a commercial property update.
Good morning, everybody. My name's Jonathan Crook. I'm a partner in the commercial property team at DMH Stallard. It's nice to be doing one of these seminars again. It's a shame not to be able to see you all, but this is the next best thing. I, for one, miss my bacon sandwiches, so I hope we'll be back looking and having those soon. I'm going to talk about a few topics today about what has happened and what is going to happen in the future. My first topic is rent suspension for COVID-19. Last March, we were all faced with an extraordinary situation where most of us had to go to work from home and shops had to shut. The immediate effect on tenants was that they were not able to occupy their property, but they had to pay their rent. So immediately tenants would wonder what would happen about their rent in their leases. Well, looking back a step, most commercial leases have a rent suspension clause. That rent suspension clause typically applies where the property is damaged by an insured risk, and that renders the property incapable of use. So let's say there's a fire or a flood and the tenant can't use the property. In those circumstances, the tenant usually gets rent suspension, and the landlord, if all goes well, will get the money back from its insurers. So what happened in March? Well, the government brought in social distancing measures which prevented the use of many properties, so the tenant couldn't use their offices. I, for one, had to go and work from home. Well, a standard rent suspension clause certainly doesn't, in usual cases, cover a pandemic having to work from home. So I'm going to look at both existing leases and new leases. Well, existing leases, we tended to be approached by landlords and tenants in March last year. What I think tended to happen was that many tenants would just write to their landlord and ask for a rent concession. They'd ask for the March quarter or they'd ask for more. What was agreed was the landlord would either say no, would give them a quarter's rent or something in between, and whatever the parties could come to. I think in most cases, the parties were quite practical about it and didn't actually use lawyers and surveyors. I think in many cases, the landlords would just say to the tenant, don't bother paying the rent for this period. However, we were approached by many clients, and it is better to document these arrangements properly. So what we recommended was a side letter being put in place, which would document a waiver of rent, let us say, under the lease. It would make clear whether it was a personal concession or not, how long it would last. And one point you need to consider, for example, is the rent being let off completely, or is it just being deferred? Who pays the fees for that letter? So we dealt with a few of those side letters. And one technical point you need to think about is if you actually vary the lease, you need to be a bit careful about the guarantor. Any potential variation might release a guarantor from liability. So you need to be very careful about that. And you'd often need to join in the guarantor. Next slide, please. What about new leases? Well, we've dealt with a few new leases since March, so tenants taking brand new leases where they weren't in occupation before. My experience of this is that tenants would sometimes ask for rent suspension, but in my experience, usually landlords said no. And perhaps in practice, many tenants were taking premises where they were fairly confident they would be able to carry on using them. It all boiled down to the bargaining strength of the parties. And I know in one case I dealt with, the tenant was a strong entity and the tenant absolutely insisted on having a rent suspension clause. So the first thing we needed to think about was what effect might that rent suspension clause have on the landlord's interest? Might it worry buyers? Might it worry banks? So we needed to take advice from the surveyors involved in that case on a potential impact on the landlord's interest. If you think about it, such a clause would have been completely unthinkable a year ago. And so you need to think about whether it might affect the landlord's interest. Then getting to the drafting, you'd be talking about a government measure, meaning the tenant can't use the property for the permitted use. You then need to think about, does it just cover COVID-19? I've seen quite a lot of drafting, which actually tries to cover other diseases as well. Again, that would have been unthinkable a year ago. You'd probably want to say that the rent suspension wouldn't apply where it's being caused by the tenant's default. We've all read some of these stories in the press where a property has been closed because the tenant has behaved badly. Now, if that's the case, you wouldn't expect them to have rent suspension. Two more tricky points. How long does the rent suspension last? Or is it indeed a deferral only? Does it go for several months? And then do you have a long stop date? The landlord won't want it to continue forever. And also, should there be a right for the parties to terminate if, for example, the rent suspension goes on longer than expected? And so should each party have a right to end the lease? Another tricky one is, how often does the suspension apply? We had to grapple with a situation where, let's say you might have rent suspension in lockdown 2. You're looking ahead, what do you do in lockdown 3? Do you get another rent suspension? What if we even have a lockdown 4? Can you keep on getting rent suspensions? So you need to look at these situations. They're not easy to draft around because a lot of it, you're not really sure what's going to happen. And just the last point is, if you have an underlease, that makes it a little bit more complicated. The landlord might take the view that the tenant shouldn't get rent suspension if there's a tenant who is receiving rent from an under-tenant. Okay, next slide, please. Completely different topic now, contracting out under the Landlord and Tenant Act 1954. The surveyors among those watching will be very used in their heads of terms to saying either a lease is contracted out or is protected by the 54 Act in commercial leases. Protected leases give tenant very strong security of tenure, a right to stay in occupation and to take a new lease, subject to certain limited exceptions. However, I'm going to focus on contracting out in the next few minutes. When you contract out a lease, you have to go through a specific procedure. I'm going to run through what that is. In the old days, I'm long enough in the tooth to remember that before about 2002, you had to go and get a court order to get a contracted out lease. So that was quite tricky. And you used to try and find a court that would do it quickly. Anyway, that's long gone, but you may still find leases with that in. Nowadays, what you do is as follows. The landlord, or usually the landlord solicitor, serves a warning notice on the tenant, or often the tenant solicitor, to tell the tenant, you're entering into a contracted out lease. These are the consequences. You won't be able to stay in occupation. You won't have a right to a new lease and no compensation, so on. That is served on the tenant. So the tenant reads that notice and you serve the notice once the form of the lease has been agreed. The tenant then does one of two things. It either swears a statutory declaration, which will mean there's no need for a delay. You can do it immediately, or it does a simple declaration, which means you have to have a 2-week delay. Now, in normal circumstances, you almost always do the statutory declaration because people don't want to hang around for 2 weeks. That's proved a bit more tricky now because some people are finding it harder to find solicitors in front of whom to swear statutory declarations. So it's a point to bear in mind on timing. You might have to have a 14-day delay. I mean, I think if people try hard enough, they can probably find a solicitor and go and meet them outside maybe, but it's not easy at the moment. Once you've done that and the landlord solicitor checks the statutory declaration carefully, which has to be in front of an independent solicitor, you then refer to the agreement to exclude. the landlord's notice and the statutory declaration or the declaration in the lease, and then you have a contracted out lease. Very importantly, if you have an agreement for lease, you need to run through that procedure before you exchange contracts. It's no good doing it afterwards. It has to be before. Next slide, please. So just moving on to a case that came out last year, which potentially affects how we do contracting out. So you'll see on the slide, TFS Stores Limited, BMG Ashford Limited. By way of background, the statutory declaration requires the person swearing on behalf of the tenant to say something along the lines of, the lease is going to start on X. Now, the way the legislation was drafted was they seemed to assume you could just put in the actual date there, 1st of January, for example. That's quite tricky because when you swear the statutory declaration, you usually don't know when the lease is going to start. So if you had to do that, you'd have to probably end up doing more than one stat dec until you were sure when the lease would start. So in most cases, you tend to put something on the lines of a term starting on the date of the tenancy to be entered into between the parties, because as a matter of law, that's when the term would normally start. So you don't usually put a specific date. Well, that led to this case. Now, in this case, there were a number of leases. The statutory declarations had various different formulations. In one case, it referred to an access date under an agreement for lease, which was some time before the lease. In another one, it referred to the date of the lease. In another one, it referred to a date to be agreed between the parties. None of these are particularly unusual. And I mean, the first one is more unusual than the others, but you've certainly seen all of them. The tenant argued to the court that this wording didn't comply with the legislation. And they said, therefore, the stat decs weren't valid and they didn't comply with the legislation, and therefore the leases were protected. Well, the court looked at that argument and said that the aim of the statutory declaration was to identify the lease in respect of which the notice was given, so that the tenant understood that that lease would be excluded. The court said it wasn't so important the actual date filled in that statutory declaration. So the court held for the landlord and said that the statutory declarations were effective. It was clear what lease was being referred to, and the declaration was substantially in the form of the order. There were also arguments about the tenant solicitors being authorised to accept service of the warning notices. That's usually what happens in these cases, and it just shows the importance of checking they are authorised. The court held they were in this case. So in this case, the contracting out was successfully upheld, but it is being appealed to the Court of Appeal, and that's going to be held in a few months' time. So watch this space. From a landlord's point of view, we hope the answer will be the same. Thank you. Next slide, please. And lastly, I couldn't do a seminar without saying a little bit about MEES, minimum energy efficiency standards. I'm finding these cropping up more and more now. And just by way of a reminder, if you have a property which has a rating of F or G, that is seen as substandard, and you can't grant a lease with F or G, either residential or commercial, if it's F or G, unless an exemption applies. That's the case for new leases for both types of property. For residential, you have to have above E for any continuing tenancies. For commercial, that comes in 2023. This consultation I mentioned is a little bit of a cheat in the sense that my slide said commercial property. This actually relates to residential property. So there's a consultation last year about improving the energy efficiency of residential property. The main proposal to watch out for is that the government is intending to increase the rating for residential property to C from E. So that means that D downwards would be substandard. That's a big change if it comes in, and something that people looking after their residential properties need to watch out for. The government's plan is to implement a phased trajectory for achieving the improvements. So it's going to apply to new tenancies granted in 2025 and to all tenancies existing in 2028, still residential. They seem a long way off, but they'll be here before you know it. And I think that if the government is thinking about these changes in residential, there's a fair chance they will also think about them for commercial properties too soon. So just watch out for that. I'm finding we're having to grapple with this quite a lot on properties at the moment. And one other thought in the consultation is to increase the maximum amount that landlords of substandard houses are required to invest to improve the energy efficiency to £10,000. So we'll wait and see the outcome of that consultation, and just watch out that it may well go to C on residential properties. Thank you very much. If you have any questions, do put them in the Q&A feature. And I'm now going to hand you over to Cheraine. Thank you very much.
I'm Cheraine Williams, a Senior Associate in the Real Estate Dispute Resolution team at DMH Stallard. I'm going to be talking today briefly about current issues in property and insolvency. So most of you may already be aware, but the Corporate Insolvency and Governance Act 2020 was introduced on the 26th of June 2020. Essentially, it brought about a number of changes which do affect a landlord's right to recover rent arrears from the tenant. But the main changes actually only affect companies and not individuals. So the position in relation to companies remains the same. Sorry, in relation to individuals remains the same. But in terms of companies, it does mean that we now can no longer present a statutory demand as a basis to wind up a company. So they essentially are void. There are other means to make a company insolvent, such as, for example, if they're deemed unable to pay their debts as they fall due, or they are balance sheet insolvent. But then the other problem is that under the Act, a landlord now cannot present a winding up petition unless it shows that COVID has not had a financial effect on that company, or essentially those circumstances would have arisen even if it has had a financial effect. So in reality, what we're seeing at the moment is no real statutory demands are being served, as essentially they're not the threat that perhaps they once were. And also we're only really pursuing things where it relates to pre-COVID rent arrears, which is obviously quite rare at the moment, as most arrears are accruing during the COVID period. Other changes brought into effect are now that a winding up petition will not be advertised or publicised until the court has decided that COVID has not had an effect on that company. So it does mean the winding up process is a bit more drawn out and there are additional costs. There is a risk, therefore, at a hearing that the winding up petition could be dismissed and the landlord is ordered to pay the tenant's costs. So the landlords do have to be careful here. The one advantage to the tenant of the changes in the process is that the winding up will now not take effect until the winding up order has been made rather than when the petition is made. This makes a huge difference as their assets will now be frozen at a later date rather than when the winding up petition was actually presented. Other changes brought about by the Act include the fact that a moratorium can now be imposed to prevent creditors pursuing any legal action against that company without leave of the court. Now that moratorium is monitored by an insolvency practitioner and can be extended on numerous occasions. Next slide, please. So what have we seen and what do we expect? So as I said earlier, we're not seeing any statutory demands against companies or letters simply demanding payment. What we are seeing is a rise in letters before action and county court debt proceedings generally against companies. But the problem with debt proceedings is that the court fees can be quite restrictive and up to 5% of the value of the claim. The other thing that we're seeing is possibly looking at claims against guarantors and previous guarantors. Now, it's quite important in respect to previous guarantors that the position is looked at promptly to ensure that Section 17 notices under the Landlord and Tenant Act, not Landlord and Tenant Covenant Act, are served on that guarantor. Otherwise, the landlord could be prevented from recovering the arrears from them. But those notices need to be served in 6 months from when the arrears fall due. Other landlords are getting concerned that their property may be left empty or difficult to relet, and therefore they're taking a wait and see approach. As you would have seen from Jonathan, our transactional team are also dealing with rent concessions, possibly moving a break date or agreeing a new lease in return for rent concessions being granted to tenants and the landlord securing the tenant for perhaps longer in the premises. One of the other things that we're seeing in the market is that there's already been a rise in company voluntary arrangements, especially in the retail sector. Now, company voluntary arrangements, as I'm sure most of you are aware, are approved by 75% in value of creditors. So mostly they will include all of the creditors and they're monitored by the IP, an IP who's acting as a CVA supervisor. Now, there has been a rise in particular in terms of like landlord only CVAs. The other issue that we're seeing is perhaps more challenges to CVAs by commercial landlords. And we've had the Debenhams case already by Mike Ashley, and we think similar cases may actually arise. Now, in terms of challenging a CVA, really when one is received by a landlord, we should be looking at the clauses because some of those can be just copy and pasted from a previous CVA and could be irrelevant. In terms of challenges in themselves, they could be challenged on the basis of unfair prejudice or material irregularity. Examples of those include, for example, that creditors can be treated differently, but as long as they basically the overall effect of the CVA is justified. Another example, particularly in terms of landlords, is the fact that their claims can be difficult to value, especially in terms of dilapidations. The other point for landlords specifically is that the CVA just cannot extinguish the landlord's property rights. That goes outside of the scope of insolvency legislation. If there is such a clause in there, then if there is a relevant severance provision, then it could be severed from the CVA, or even if there is not, then the CVA could be revoked or suspended. So it's important to look at that in particular. We have seen cases where, for example, the conditions relating to forfeiture are varied, but it cannot remove the right to forfeit entirely. So in terms of the new act that's been brought in, it has already been extended on numerous occasions, and at the moment it's in place until 31st of March 2021. But with obviously a further lockdown being introduced and new variants of the coronavirus, we would not be surprised if it's actually extended further. So that's it for me for now. If you've got any questions, please put them in the Q&A function on your screen. And I'd now like to hand you over to Emily Wood. Thanks.
Thanks, Cheraine, very much. So I'm going to briefly take you through some updates on business rates. There was loads to choose from to talk about in this area, but I just want to give you a brief update of some of the things that we've been seeing the most. We'll aim to cover some areas of business rates in more detail in later seminars. So even before the pandemic, high streets were struggling, as we know. A number of large retailers were restructuring, stores were being closed, and retailers being wound up. And business rates has been heralded, if that's the right word, as one of the reasons for this decline. And that's perhaps no surprise when in many cases, rates can be as much as rent for some occupiers. So when it came to the lockdowns, you can see that this exacerbated the issue, and hence business rates has become a real hot topic with the government and in the news. The government did rightly provide relief for some during the pandemic. 100% business rates relief for certain businesses during COVID-19. That's potentially proved a lifesaver for some, but it is limited. It's limited to occupiers and not the owners of these types of buildings, when they can sometimes obviously be vacant now, and to a narrow category of businesses, so to retail, hospitality, leisure and nurseries. And it all at the moment currently ends on the 31st of March 2020, with no relief, as we know, at the moment after that. With some commentators predicting that lockdowns will be in place until at least May 2021, these reliefs are set at the moment to end too soon. However, there is perhaps some hope on the horizon. The Chancellor's spending review in November said that the government was considering further options for COVID-19 related support through business rates relief. And plans for the next year, for 2021 to 2022, will be outlined in the new year. We're already nearly at the end of January and still waiting to hear. For those not benefiting from these limited reliefs, there is always the option of mounting an appeal against current levels of rates. And wow, have we seen plenty of these. Over 183,000, in fact, for the period April to October last year were lodged, compared with only 153,000 in the previous 3 years. Not all of these appeals, but certainly many of them, are what's known as MCC appeals, where a material change in circumstances has resulted in a previous assessment of rates being no longer relevant. The appeal regulations do narrowly describe what amounts to an MCC, and the question has been whether what's happened in our offices and other commercial space during the pandemic does fit within that definition. The majority view appears to be that COVID can amount to an MCC in a lot of these appeals, and therefore a fair amount of them should be successful. But the trouble is the time lag. You have to pay your rates whilst appealing, and an appeal could take at least up to a year. So it's not an instant assistance for many of our businesses, and sadly for some may just come too late. Another option for others might be to use a rates mitigation scheme. A popular attempt has been to reduce rates by using property guardians as a means of mitigating rates in relation to empty properties. Plenty of commercial properties have become vacant during the pandemic, and property guardian schemes don't only offer potential rates mitigation, but also security against trespassers. How it's worked is that property owners enter into an arrangement with an operator who in turn grants short-term licenses to individuals to live in, say, an empty office block, and the fees paid by those individuals are then shared between the operators and the property owners. Until recently, this arrangement resulted in many local authorities treating the building then as residential and charging council tax as opposed to business rates, which is generally a lot lower. However, in December, the Court of Appeal decided in a case about this sort of arrangement, saying that it didn't have this effect, that the building owner remained liable for business rates. That was the Southwark London Borough Council and Ludgate House Limited case. We're therefore expecting to see a fall in these type of arrangements, but that's not to say some arrangements won't still work depending on the wording of the contract with your property guardians. And there are, of course, other rates mitigation schemes available to use. Next slide, please. Looking to the future of business rates, certainly one issue with business rates, which has been exacerbated through the pandemic, is that the level of rates being paid are based on property valuations from 2015, so relatively historic. There are plenty calling for more frequent revaluations, so business rates accord with current values and take into account events such as pandemics and that effect on the property market. In an attempt to realign rates and the market, the government's revaluation was scheduled for the 1st of April 2022, and that would have been based on property values as at April 2019. But because of the pandemic, for good or bad, the government's postponed that due to COVID-19, and the next rating revaluation in England will take effect on the 1st of April 2023, based on property values in April of this year. If this does go ahead, it will be interesting to see how COVID plays a part in these valuations. But it does still mean that ratepayers' liabilities will be continued to based on pre-COVID values until what we hope will be a time way past the pandemic in 2023. Looking at possible reform, a fundamental review of business rates was announced by the government to be on their agenda last year. The government called for evidence from relevant stakeholders, and the closing date was the end of October last year. The idea was a report was scheduled for spring 2021, so we're waiting to hear more. Whenever that review happens, what has to be on the cards is a move away, we think, from taxing bricks and mortar. This has really been illustrated by the effect of the pandemic on our use of offices, shops, etc. The biggest winners in our shopping habits have already moved rapidly to online, and they're not on our high streets or in our shopping centres. They're the likes of Boho, who's now swallowing up Debenhams brand and online presence, but not its stores, or ASOS, who's looking to do the same with Topshop. And if, heaven forbid, offices also become more of a rare breed as well, physical property tax just doesn't seem to be in sync with our market and not fit for purpose. So a fundamental review is really needed, and we watch this space. I'd now like to hand over to Lawrence
Thank you, Emily. Good morning, everybody. My name's Lawrence Morley. I'm an associate in the firm's real estate dispute resolution team. I have to say it's nice to be wearing a shirt and tie for once. That's not been a common occurrence in the last number of months. I'm just going to spend a few minutes of your time just to finish off this seminar, talking about how 2020 has affected a landlord's right to possession of commercial and residential properties for rent arrears and how the situation may look in 2021. Since March 2020, landlords have been prevented from accessing their usual arsenal of rent recovery options, and the right to possession on the basis of rent arrears has been significantly curtailed. So, pre-COVID-19, if a landlord wanted to seek possession for rent arrears, they would have to rely on the forfeiture provisions in their lease. As a quick reminder, forfeiture is where a landlord elects to exercise their contractual rights to determine a lease upon the happening of a specified event. So in this case, the non-payment of rent. And a landlord would need to do two things initially. They'd need to check their lease to make sure that there's a forfeiture clause, also known as a right of re-entry, and check whether the right to forfeit has arisen. Then what a landlord can do is they can either issue proceedings or peaceably re-enter the property, remembering at all time that a tenant is entitled to seek relief from forfeiture by paying the rent arrears, and this will mean that the forfeiture doesn't take effect and the landlord doesn't get possession. So in March, the government passed the Coronavirus Act 2020, and as far as commercial property is concerned, we need to look at Section 82. And what this did is it imposed a suspension on forfeiture. This ran until the 30th of July 2020 initially, but it was extended to the 31st of March 2021, so a couple of months' time from now. And what this means is that a landlord can't exercise their right to forfeit a lease on the basis of a tenant's non-payment of rent during this period. It doesn't mean that the right to forfeit doesn't arise. It just means that the landlord can't exercise their right and use it to try and seek possession. So it's always worth remembering that the rent owed during this period is still due and will continue to accrue. It also must be pointed out that a landlord won't be regarded as having waived their right to forfeit for non-payment of rent unless they expressly confirmed as such in writing. So as a result, once the suspension period ends on the 31st of March 2021, a landlord could forfeit the lease on the basis of a tenant's non-payment of rent that has accrued during the suspension period if that rent remains unpaid. Just finally on that, it's just worth pointing out that the suspension only applies to forfeiture on the basis of non-payment of rent. Landlords often have other grounds on which they can seek forfeiture as contained in the lease. So it's just the non-payment of rent. Next slide, please. So looking forward to 2021, we've obviously got the March 2021 date. Just a few questions really, just to speculate as to what might happen in the future. Will there be a further extension of the forfeiture suspension? Maybe. We'll have to wait and see. The government, when they announced this extension from the June dates, they did say that this was going to be a final extension, although circumstances have changed quite a bit nationally since then, obviously with the further lockdowns. So I wouldn't be surprised if they have a rethink, but there's been no announcements as yet. So at the moment, there is no further extension. Will this cause an open season for landlords to seek enforcement action if there's no extension, of course? Possibly. I would probably say unlikely. Landlords could theoretically exercise their rights to forfeiture again, but many will be wary of having empty premises for rates liability, etc. And I'm sure a lot of landlords would prefer to negotiate with their tenants to try and keep them in place rather than removing them. There's also the question as to whether the government decide to make a distinction between pandemic debt that has accrued between March 2020 and March 2021 and new debt that becomes due after the 31st of March 2021 with regards to a landlord's enforcement options. They haven't made any announcement as such yet. So this is sort of a bit of speculation on my part, really, but it's possible that they may say that landlords can seek forfeiture on debt that becomes due after the 31st of March 2021, but not before. But as I say, no announcement yet, so we'll wait and see. Next slide, please. Okay, so that's commercial property. Now just dealing for a few minutes with residential property. Just looking at the situation again in 2020. Pre-COVID, if a tenant was not paying all or some of their rent, then the landlord may be able to seek possession by first serving notice under either Section 21 or Section 8 of the Housing Act 1988. Section 21 procedure, that is initiated by the service of a Section 21 notice, is often seen as easier and quicker, but can only be used if the fixed term has expired or is about to expire by the end of the notice period. And the notice period for that was 2 months pre-COVID. Section 8, by contrast, is a fault-based procedure. So the tenant has to have done something wrong, i.e. not paid rent. And that again is initiated by service of a notice, a Section 8 notice, and that can be served during the fixed term. So it can be done earlier than a Section 21 notice, but it's more grounds to challenge. And if a tenant repays all of the rent, then they're not in breach at the date of the hearing. And the notice period was 2 weeks if you're relying on rent arrears ground for a Section 8 notice. So what the Coronavirus Act did, Section 81, Schedule 29, they increased the notice periods that need to be given in Section 21 notices to 6 months and Section 8 notices to 6 months, unless the tenant is 6 months in arrears, in which case the notice period for Section 8 is 4 weeks. And as with the commercial property provisions, this is the case until the 31st of March 2021. Next slide, please. The government also announced last year a stay on possession proceedings, and this was in place until the 30th of September 2020. Obviously, that date is now passed, and the courts are now accepting new claims and applications to reactivate stayed claims. So if a landlord had made a possession application last year, it's likely that that claim would have been stayed, and the court will only deal with that claim again if the landlord files a reactivation notice. So they're waiting for the parties to ask for their cases to be dealt with again. They won't do that automatically. Since September 2020, of course, therefore, new claims can be made and claims reactivated. So if landlords have managed to obtain possession orders, which I've on a couple of my matters, a lot of those landlords are still unable to enforce them if the tenant refuses to leave. The only way to evict someone from a residential property following obtaining a possession order is by instructing bailiffs. But unfortunately, the government announced a ban on most, not all, but most residential evictions until the 21st of February 2021. That was actually a 6-week extension from a previous date in January. So up until that date, unless the tenant is in very substantial arrears and other limited circumstances, bailiffs won't be accepting new instructions. Next slide, please. So finally, just a few questions. Again, just to look forward to 2021. Will notice periods revert back to the pre-COVID levels, or will there be a further extension? Difficult to say. There's not been any announcement. I wouldn't be particularly surprised if there was an extension, but we will have to wait and see. If there's no announcement before the end of March, then no, they will go back to the previous period, which will be of benefit to landlords. Regardless of whether they do or don't, the courts are currently working through a backlog of possession cases, new and old, as I just alluded to, and that's likely to continue into 2021. So I would say that most, if not all, possession cases are likely to take that little bit longer. Will residential evictions be allowed again? As I said before, they're allowed still at the moment in limited circumstances, but on the most part, will they be allowed? I would fully expect that February deadline to be extended again, to be honest. In November, when it was first announced, the Housing Secretary said that possession orders wouldn't be enforced for residential properties whilst there was a national lockdown in place. Given what we've heard from the government over the last few days, it sounds as though March is probably when we're going to see a roadmap, and I think we'll be in lockdown until then. So I would expect the 21st of February date to be extended, but we'll have to wait and see. And lastly, the government have made a couple of announcements over the last year or two, stating an intention to abolish Section 21 notices altogether. It may have been thought that this legislation may have been sort of brought into place sort of around now. Other things have obviously taken precedence. So will we see any reform to Section 21 this year? Possibly. I think at best there might be an announcement about it, but I'd be surprised if any legislation is rushed through. But we will have to wait and see. So that's all from me. Thank you very much, everybody. I'm just going to pass you over to Emily again, who I believe is going to be quarterbacking our Q&As. I think there are a few popping up. So I'll pass over to Emily. Thank you very much.
Thanks, Lawrence, very much. So if I can invite all our panelists back onto screen. Yes, thank you very much for all your great questions. We'll get through as many of them as we can over the next 10 minutes. So Chloe, if I could turn to you first, we have a question regarding the new permitted development planning rights. Does this effectively mean previous Article 4 protections have dropped away?
Yes, so there's a couple of things to know about that. So an Article 4 direction is a direction issued by a local authority to remove a specific permitted development right in part of its authority. So in terms of the new permitted development rights that have been introduced, a local authority would need to issue a new Article 4 direction relating to that if they wanted to restrict the use of that permitted development right in a particular area. That's not an easy process. It takes about a year. So there will be a period of time where the permitted development right does apply before that comes into effect. And in terms of the existing permitted development rights, in respect of the change of use of the use classes, effectively the way that the use classes order and the permitted development rights work is that you take into account the new permitted development rights with regard to the new use classes. So the same Article 4 directions will apply to the existing use permitted development rights referred to as the new use classes. So there's a couple of separate things there.
Thanks, Chloe. That's really helpful. Jonathan, can I turn to you with one of our questions, which is there any indication when we will hear the outcome of the MEES consultations for resi and commercial?
I can answer half of that. On the residential one, I know that the consultation has just closed, unfortunately. So if anyone wanted to make any representations, I believe that's too late. When the outcome, when the result, the government's view will be given, I'm not sure is the answer. And on the commercial one, I need to check that. I believe the government did launch a consultation about a general roadmap, as they called it, up to 2030 and how to change for commercial properties. I need to look into that further to check where that's got to. But on the residential one, it's just closed and we'll just have to wait and see when the government come back on that.
Okay. Cheraine, got a question in on your topic. Please, can you repeat your comment about the relevant date in corporate winding up? The writer thinks that you mentioned that the date of the order is now the key date for looking at transactions as opposed to the date of the petition.
So it's basically under Schedule 10 of SEGA in particular, Part 2, Paragraph 9, which means that basically previously under the Insolvency Act 1986, Section 129, Paragraph 2, where it used to start on the date of the petition, it's now in the date of the order. But there are also, I haven't gone into detail obviously in my talk, but there are also relevant provisions in that schedule looking at when you're looking at transactions at undervalue, etc., and when the date starts. So it's probably the starting point is to look at Schedule 10.
Okay, thank you. Lawrence, question for you. Someone asking, how long do the courts take to give you a possession order once you've actually served your notice and issued?
Very difficult to say, really. I mean, what the courts are doing at the moment is they're trying to prioritise the old cases and the new. They're trying to deal with the most egregious and urgent cases first. I recently did a case for a client who was owed rent arrears. They decided that because they were so desperate to get the property back, they didn't want to claim those rent arrears as well as the possession. So they used the accelerated procedure, which is generally, as the name would suggest, a lot quicker because it tends not to involve a hearing and the court could deal with it on paper. So that process took a couple of months all in, from issuing to getting the possession order. We're still having issues enforcing it, as I mentioned. Generally, they are taking a little bit longer because the courts are putting in review hearings to find out what's been going on in cases and look at the effect of COVID on, especially on the tenants. So I would probably estimate sort of 3 or 4 months to be getting from start to finish. At the moment, but it really depends, and of course you issue at the closest county court to the property, and different county courts work more efficiently than others and have more cases than others. So yes. Sorry, I can't be much more clear than that, but it will take longer than it was previously. That's all I could definitely say.
Yeah. Okay, Chloe, another one for you. On commercial to residential, which has prior approval, our audience member has said, I've been told that as its existing use is commercial, permission for change of fenestration is required. Is this correct? Or by automatically being allowed for residential, which fenestration change does not require permission? Is it the rules, or does it come under impact on local amenity?
Okay, so this is, I think, essentially a question about what can you do within a permitted development right, and that depends on what the permitted development right says. So, for example, office to residential is a simple permission of a change of use, and if you wanted to change the fenestration or do any other operational development works, then that would require separate planning permission. But on the new permitted development rights, for example, the demolition and rebuild to residential, as I mentioned, that does allow, obviously, rebuild. And one matter that the local authority can take into account there is appearance. So that would include fenestration. And also impact on local amenity does take into account overlooking and things like that, which windows may come into as well. So it really does depend specifically on the permitted development right.
Okay, just a couple more. One for me. What date did I say the 2023 revaluation would be based on? So that's the 1st of April 2021. So 2 years prior, as usual, the values will be looked at. So nice, easy one there. And then, Jonathan, another one for you. What's the position on EPCs on listed buildings?
It's quite tricky on listed buildings. There used to be an urban myth that you don't need EPCs on listed buildings. The take-home message is you may need an EPC on a listed building. The legislation is quite tricky and circular. So if you are advising a property owner who has a listed building, you need to take specialist advice. You may need to get an EPC assessor along to have a look at the property to see if you need an EPC. So the important point to remember is they are not automatically exempt. There are specific exceptions, but it's quite complicated, but they're not automatically exempt. You need to look at each property on its own basis, and it may depend on whether the features of that property can be amended or not. So just remember, they're not exempt automatically.
Okay. So with 1 minute to go, we're going to squeeze in one last question for Chloe and then wrap up. So Chloe, what distinguishes a village shop, local community, from a Class E shop for planning purposes?
That's a really good question. So the village shop, so the local community new use Class F2 includes shops which mostly sell essential goods, including food, where the shop's premises do not exceed 280 metres squared and there is no other such facility within 1,000 metres of it. So that really is the government trying to secure effectively rural shops, village shops, where there's nothing, there's no retail park or anything nearby that somebody else could obtain essential goods from effectively. So this is the government trying to protect these rural communities and secure their village shops, whilst allowing retail units in the high street and in town centres, things like that, to remain Class E.
Okay. Well, hopefully that's addressed at least some of your questions, and thank you for those, and thank you for joining us this morning. We'll be back in March for the next webinar, and maybe even after that a seminar, which would be great to see you all in person, obviously. But thanks for joining us. If you do have any topics that you would like us to cover in the future, we would really appreciate any ideas, so do pass them to us, and we'll be able to hopefully cover them in future. So thanks very much for joining us. Goodbye.
Thank you.
Thank you.
Thank you, everybody.